Good morning, everybody. Thank you for attending the webinar this morning. We're just going to give it a couple of minutes for people to join and settle in. So if you do want to go off and grab coffees and teas and whatnot, then please do. And we'll start in a minute or so. Morning to everybody who's joining. We will aim to start in a minute or so, just give people time to join us and settle in, and then we will make a start. I'm going to start sounding like a broken record, but good morning to everybody who's just joined. We're just giving it a moment just for everybody to settle in, and then we will make a start. Good morning, everybody. We'll be starting very shortly, just waiting for the last few people to trickle in. Great. Well, I think we'll make a start because I know everybody's got extremely busy weeks this week. So the first thing to say is a massive thank you for joining us this morning, which is the Wednesday of ASB Awareness Week. So a huge amount going on in the world of ASB. And so we are very grateful for you making the time to spend the morning, well, the next hour. Please don't worry, we're not going to keep you here for 3 hours, but the morning with myself and Lindsay. Just in the way of a little bit of housekeeping to start with, we are using the webinar functionality of Teams. That does mean that everybody's on mute and they're not able to put your video on. That simply is just a way for us to control things like background noise, people accidentally keeping themselves unmuted. It is not in any way to stop you being able to engage with us or ask questions. You will see multiple different ways of doing that. The chat box, people have already popped hellos in the chat box, and we also have the Q&A box where you can put questions in there. What we would usually ask is if people can keep their questions to the question and answer box. That's really helpful for Lindsay and I, because obviously we'll both be talking through this session. So sometimes it's really difficult to identify what are questions within the chat box when they kind of get lost around all the hello and general conversation. So we'll be looking at the question and answer box to get your questions from. So please type it in there if there's something that you would like to ask us. But as always, you can always contact myself and Lindsay following this session if there is anything that hasn't been answered for you, or perhaps you haven't had the chance to ask, or perhaps I've missed in the midst of multitasking. So my name is Janine Green. I'm a partner in G&B ASB Associates. I recognise lots of people's names on the screen today, but for those of you who perhaps I haven't had the opportunity to meet before, been working in antisocial behaviours for sort of over 20 years now, and my business provide antisocial behaviour services to local authorities, police, social housing providers, and others increasingly as things change. I'm joined by Lindsay, and I'm just going to ask Lindsay to introduce herself because otherwise I'll get her job title wrong, as I usually do, or pronounce her surname wrong. So I'm going to let you do that a bit, Lindsay.
I mean, we've only known each other for a very, very long time, haven't we? Good morning, folks. Welcome to the session. I am Lindsay Felstead. I'm a partner. I head up our national housing management team at Clark Wilmot, and I am also joint sector head at the firm. So dealing with anything and everything social housing, but mostly related to housing management on behalf of local authorities and RPs.
Lovely. Thank you so much for joining today, Lindsay. So just to give you a bit of a understanding about why we're here this morning, obviously we are kind of aware, I imagine most people in the room are aware that we now have a Crime and Policing Act. We had a bill for what felt like a long, long time, and we finally now have an act which gives us some details of what the future looks like in terms of the ASB toolkit. But as is the way with all legislation, it's not nice and easy. It's not, it came in April, and therefore we started using it in April, and we had all the guidance and all the templates and all the training ready to go. Of course, it's never that simple. So there's been lots of things coming out about changes, lots of things coming out about royal assent, commencement, changes to statutory guidance, consultation on different things. And we'd started to get quite a number of questions. And we thought, you know what, let's just do a really informal, relaxed session where all the questions that we've received and heard from working with lots and lots of professionals over the last few months, we will literally just answer those questions. And knowing me and Lindsay have a little bit of a discussion around some of it as well, I should imagine. So we're going to be here for about an hour, really relaxed. So it might be slightly less, it might be slightly more. If you need to leave, that's absolutely fine. If you are having any sound issues, any tech issues, I can't solve them for you. I'm really sorry. Just outside my capabilities. I can sort you an injunction, but I can't sort your IT problems. I'm really sorry. I can barely sort my own half the time. But we are recording this. So as always, the recording will be openly available on the resource area of our website, as is all our past recordings for webinars and various guidance and blogs and articles and whatnot. So I promise, even if you can't hear me right now, which you're going to have no idea what I'm saying anyway, but you will get the recording at some point. So please don't worry. So, as I mentioned, we're here because we've got a new piece of legislation. We're here because there's lots of different questions around that piece of legislation. And so I'm going to pitch some of the questions that you sent to us in advance to Lindsay. And where we're going to start first and foremost is by sort of the general questions about where we are with the Act at the moment. So we are at a point where we have had royal assent, and that happened a couple of months ago now, I think. And I suppose what might be just a really helpful place to start for the non-lawyers in the room is just if you could explain what royal assent actually means, Lindsay.
Yeah, of course. So it basically means that it has gone through the process that it has to follow. So the bill has then been debated, it's been changed, it's been reflected on, it's gone through the various stages of that. And all of that then has concluded, and royal assent has been given, which means, yes, this piece of legislation can be brought into effect and can be brought into law, but not that it is good to go yet. So everything is there. The law is written out. That's why we have the Act. But that of itself does not mean that the Act is ready to be used.
Yeah, I mean, put quite simply, Lindsay, it is literally administrative stuff, isn't it? It's the King saying, yes, I agree that this can become law. I suspect that our beloved King Charles didn't go through the Crime Policing Act line by line to see if he agreed with everything. But it is essentially the King ultimately responsible for legislation who is given their approval for it coming into law. So royal assent, I think, sometimes confuses people, and understandably. And one of the questions we've had is, well, can we use the tools now? And we're waiting for commencement for that. And so that's slightly different, isn't it? And I don't know, maybe if you could explain sort of the process of how commencement comes about.
Yeah, absolutely. So basically what will happen is, and it can be at various stages. So actually some things have started to be law and able to be used, very, very, very small portion of that. But what will happen is Secretary of State over time will say, yes, this bit's good to go, and we are notified that it's good to go and that it's taken effect and can be used. That often is a phased approach. sometimes because other things need to be in place for parts of legislation to work. So that will be the process, that we will be advised when certain parts of the Act will be ready to be used, and the Secretary of State will announce that, and we will have the commencement dates of when that will be.
Yeah, and we should get those in advance. I mean, there'll be basically a statutory instrument or something published, won't they, which will give the sort of
Yes.
information that allows us to see when those commencement dates are to be. And I think the perfect example of that kind of staggered introduction was actually probably the ASB Crime and Policing Act, because exactly as you've just said, we had the bulk of the powers that came in October 2014, and then sort of somewhere towards the date, someone realised that there was some legal aid issues with the injunction, and realised that the injunction wasn't quite ready to come into force, and so the injunction didn't commence until March of 2015. And I think that's a perfect example of where there were things that needed to be done before the injunction could commence.
Yeah, absolutely.
So simple answer is no, we can't use the tools at the moment, business as usual, but wait for those commencement orders, which will give us the dates for where we can start using them. You mentioned there, and I think it's quite helpful to pick it up perhaps, that some things have come into force, which is actually quite topical because it was only a couple of days ago. I don't know if you've had I don't want to throw you into it, Lindsay. I don't know if you've had a chance to read them with everything else that's going on, but if you're able to just give us a summary.
I have not read everything that has come into force. In part, can I just say, for my own kind of preserving my reputation, that the bits that have come into part don't directly relate to antisocial behaviour, housing as such. Hence, nobody be alarmed that works with me. But we have had some things like, for example, a piece of law that has been around for a very long time, the Vagrancy Act, which made rough sleeping criminal offence. That has been repealed, and a section that has come in place now relates to the facilitating begging for gain. So that's an example of something that has come into force and is ready to be used, but nothing yet in respect of the ASB powers or the offences related to the ASB powers that housing providers will have.
And it's helpful probably to bring in here, there was a question in the chat box. I'm so sorry I didn't catch the name of the person that posed it, but asking whether the criminal offence of cuckooing had come in yet. And my understanding is that's not covered in what's in force now.
It definitely isn't. And if I could just take the opportunity to talk about that offence, because I have a very particular view, which is on the face of it, wonderful that is an offence, that we have a vulnerable person who, you know, has been taken over and their property has been taken over, and then obviously ASB is perpetrated from that property. In theory, this is wonderful. However, when you look at the offence of cuckooing, it is going to require that vulnerable person to be giving a statement about the fact that they have effectively, you know, been corrupted by some individuals who have this power over them. To me, that is a very definite conflict. We've got a vulnerable person who ended up in a situation where their home was overtaken by individuals, but by the same token, they're expected to be giving evidence that this has happened, and, you know, potentially coming forward to give evidence that this has happened. I just genuinely don't see how that is ever, or at least very often, going to be something that we're going to get the evidence for, and therefore a prosecution can take place. People might have a different view, but that is very definitely my view. It's a bit like domestic abuse offences, isn't it? And obviously powers were brought in so that actually people could be prosecuted if the complainant wasn't coming forward. But that definitely wasn't an easy, and isn't an easy thing to do. It's a little bit like that, isn't it? You're the victim, and a vulnerable victim, but you're going to have to be the one to take a stand and provide the evidence that's needed in order for the offence to be made out. So sounds wonderful. I am not convinced, but I will happily eat my words if it turns out that people are being convicted of that offence, across the board.
Yeah, I do share your view. I met with the Home Office when they were kind of consulting around the offence, and I spoke very similar in terms of what you've just mentioned, which is it'd be interesting to see how many prosecutions there are under the piece of legislation. I think from my perspective, it's right that it's a criminal offence. And I guess the hope is that actually it being a criminal offence in itself will maybe one, highlight and educate the issue so it becomes people are more aware of it. Secondly, it might deter people if they believe there's
Absolutely.
perhaps more consequence. And of course, even if it does that in just one of 1,000 cases, that's of course
Yep.
positive. But I think it very much is one of those situations where it is part of a toolkit. And actually, we're back in that conversation that we have all the time, which is, for a criminal prosecution, we need a criminal standard of proof. For closure orders, we need a civil standard of proof. So it's still going to be very much there's still going to be a very big role for closure orders in terms of protecting and dealing with cuckooing issues as well.
Yeah, absolutely.
But no, thank you for raising that. It's just worth, I guess, summing up because there is a couple of mentions in the new sections that have come into force on the 29th of June. We're July now, aren't we? I was going to say 29th of this month, but we're actually in July now. So the sections that came into force on the 29th, there is a couple of references to ASB, but just so we're really clear and not confusing anyone, they aren't in relation to the tools like Lindsay says. What they are basically doing is setting the scene, doing the admin work to allow those tools to come into place later. So we'll come on and speak about the changes to closure orders because, again, lots of people in the room will probably have picked up that there was an amendment put forward by the House of Lords to extend the maximum duration of the closure order. And you may have also picked up on the fact that the House of Commons, because this is where we get ping pong, both houses make suggested amendments and then they fling it back to the other house and the two houses have to basically agree through a load of compromises and negotiation. And so the House of Lords wanted a longer duration for the closure powers. The Houses of Commons said, yes, we see that there is some value in that, but actually it's too late in the day now for us to be able to bring this into the Act now. We're too far down. We need you to go away and do some consultation and look at the impact of longer orders. But what we'll do is rather than do it so that the law would need to be sort of started from scratch when we decide how long to make those closure orders, we will give the Secretary of State the discretion, the power to be able to later on say that those periods have been extended after a period of consultation. And so what came in on the 29th was that power for the Secretary of State to do that. And we'll talk about what that looks like shortly. The other thing that came in on the 29th was, again, some of you may have picked up from the Act that there is a section in there where organisations, local authority, police, and anyone else that the Secretary of State decides to ask of have to publish information around antisocial behaviour. And again, what the legislation on the face of it says is that it's up to the Secretary of State to decide what data is being requested. And so what came in on the 29th was the section that gives the power the Secretary of State to do that. So we still don't know what they're going to ask for, but what we know is the Secretary of State now has the power to ask for it. So it's those almost preliminary administrative things that have come in rather than the tools themselves. I hope on a Wednesday morning after only one cup of coffee that made some level of sense. I just want to move us on a little bit because, again, as we've sort of followed the journey of the Crime and Policing Act, we have heard things like, oh, there's going to be pilots of respect orders, etc. And I think that was a commitment that was made some time back because practitioners will probably remember that there was no formal consultation around the tools in this toolkit. So if you think back, if you've been in ASB as long as I have, you think back to the ASB Crime and Policing Act, we had quite a big period of consultation with practitioners before that legislation was put to Parliament, where we were allowed to give thoughts and give the Home Office views on what was needed, etc. We didn't have that with these tools, and so there was a commitment that there would be a piloting of some of the orders so that we could kind of have our input and our say that way. I think that was the plan, but I know we talked about this earlier, Lindsay. I mean, I'm not. What's your view in terms of the likelihood of piloting of things like respect orders?
I don't think it's going to happen. I really don't. And I can't really see how it could, to be honest, because obviously we've got which I know we'll come on to, but we've got the different thresholds and tests for the different injunctions. And actually they potentially only work if everything is coming into force at the same time. But certainly from the guidance and how it is being framed, it's very much these powers will be ready to go as soon as we tell you that they're ready. There is literally no mention whatsoever anymore of a pilot. So I really don't think that there's going to be one.
No, and it seemed that plans had got quite advanced because, they were even starting to talk to areas about who would be interested in piloting. But I share the view. I mean, I'm not going to put my mortgage on it, on my house, but I certainly, from everything I've read, I would say 99% certain that there aren't going to be any piloting of the orders. Whether that's a good thing or a bad thing, but I guess it's for us to almost pilot them as we start using them and see how it goes. There is a question in the chat box, in the question and answer box, that I just want to pick up before we move on. And it's around, hoping that we get enough notice from sort of from the point of getting the commencement order to the tools actually being available to use. I don't know the answer to this question. I don't know if there is a set prescribed period where we have to be given X amount of advance notice, but I'm not sure. I don't know if you have any.
Wouldn't that be wonderful if
Yes.
if there were some set periods of time? No, there isn't. I think that all I can say about that is what you would hope, and it is a big hope, is that for the different parts of the Act that are going to require more effort, and I have to say, the enforcement tools, I don't think are going to be the ones that require more effort. I think it will be relatively straightforward to bring those in on a shorter notice period than other parts of the Act, so that I hope they will kind of take that into account and think, okay, yes, this is going to take a bit longer for an organisation to do.
Yeah, I suppose the problem is that very often with this stuff is that we get people making the decisions who don't know the detail in practice. So,
Absolutely.
We're expecting, people, policy writers, law writers, to have an understanding of how long it might take us to be ready for this stuff, and I don't think they always have that. So
no, and that's right. And again, it might be something that we come on to in a bit more detail later, but I can see a comment in the chat about policy changes need to happen. Absolutely, that is the case. Do not wait. We know that this stuff is coming into play. You need to be getting started on those. There's no reason or need to wait in respect of starting to make some draft policy changes so that you're ready.
Yeah, we've already seen people kind of book us in for work for kind of November, December,
Exactly.
January time, saying we know we're going to need our policy sort of reviewed. Fairly light touch, I would imagine. It's kind of making the changes in removing reference to certain tools, etc. But people do need to start thinking about that. If nothing more so, then it's just the internal process that policies take for approval. So actually, there's no harm in getting some of that stuff started now anyway. We know what the law says. We don't have the statutory guidance amendments, but actually from the kind of level that a policy is usually at, probably the details of the statutory guidance are, one, going to be quite predictable, and two, probably not going to change too much what we might deem fit to put in a policy.
Yeah, absolutely. And I think that in terms of the enforcement tools that will be available, For RPs in particular, there are some hoops that they will need to jump through. And so those types of things can and should just be covered by the policy quite easily.
Yeah. I mean, we were going to talk about things that people can do to prepare, and I think it's probably helpful to pick up on that now. So certainly policy side of things. I think also, looking through things like the respect order legislation, it does ask us certain things like a risk assessment, which, we'll come on and talk about a bit more. So we should be thinking about starting to create those kind of templates, that
100%.
we have to give a written warning for kind of a breach of a activity requirement and a respect order. So it'd be really helpful to have a template for that written warning. I think there are real clear things that we can start thinking about now. I think one of the biggest things actually is just having a sit down with our partners and going, right, more of us now can use some of these tools. That's brilliant in the sense that, the more we can do, the better. But actually what more people involved does is also create more chance of duplication, contradiction, confusion, that who manages what case. I think these tools coming in are actually a fantastic opportunity to have those partnership conversations, to sort of think about, okay, so what kind of situations might a housing provider use a closure order in? What kind of situations might it be the police? How are we going to let each other know of what we're doing? And I think now is a really good opportunity to start doing some of that as well.
Yeah, absolutely. Yes, I agree.
We talked about I mentioned very briefly there the statutory guidance. My understanding, although again, say we heard this in relation to the respect order pilots, was that there will be consultation around amendments to the statutory guidance. I haven't heard any different in relation to that. But equally, I haven't been informed of any kind of set timescales in terms of when we might see draft stat guidance. I don't know if you've heard anything different, Lindsay.
No, I have no more information on that. And it is one of the things, isn't it, that then kind of, I think it's things like that that make people a bit anxious about the new tools coming into play, because we don't have that. We don't know when we'll have it. We don't know what form that's going to take. So no, unfortunately, it's the downside of new legislation. This happens all the time, that we, end up in this situation, and there will absolutely be a period of everyone just needing to get to grips with everything as and when the information is released.
Yeah, cool. Okay, so hopefully that's given us a nice kind of setting the scene in terms of where we are with the Act, sort of anticipated timescales. Not that we've been able to help much around that, but at least you know what we believe to be the score at the moment. And it might be helpful now to perhaps if we look at some of the questions that we received in relation to, if we start with the respect order, and just I'm sure everybody in the room is well aware of this, but just to kind of set the scene in terms of, I always think of we had the injunction, the Part 1 injunction within the ASB Crime Policing Act, and it almost feels like it's been sliced into three. So we now have the respect order, which is for over 18s. It's supposed to be for more serious antisocial behaviour. So we've got that harassment, alarm and distress or distress threshold. And it's a bit more quasi-criminal. So there's sort of elements of civil and criminal involved with that respect order. The sort of second chunk of what was the Part 1 injunction is now the housing injunction. And then the third chunk is the youth injunction. So, splitting one tool into three, essentially. So we've had a few questions around the respect order. And I think some of the confusion has come from the kind of reference to the criminal breach on criminal sanctions on breach, etc. So first, let's keep it nice and simple. So who can use the respect order?
So the respect order will be available to lots of people, but very definitely the police, the local authority and RPs. So all three of those agencies will be able to apply for a respect order.
Yeah. So talk us then about the process of where to apply, etc. Because again, I think because of this kind of straddling civil and criminal, there are some some questions around where are we applying to, where are we taking breaches to, etc.
Yeah, absolutely. So some things just haven't changed at all. So all kind of the respect order is still going to be an application that is made in the county court. It is a civil remedy. So it will be an application that is issued in the county court. It will be heard by a district judge in the county court, and it will be for that judge to determine whether to make that order or not. I think where some of the confusion comes in is that because breach of a respect order will be an arrestable offence, the police will be able to arrest somebody that they suspect has broken the terms of the respect order. But unlike the current civil injunctions, where, and again, I know, and it still happens, believe it or not, across some areas, the police then, with the current injunctions, would be, okay, we've arrested this person. My brain now thinks we're in the criminal proceedings. Obviously, for the current injunctions, you take them to the county court for enforcement. With the respect orders, the difference is going to be that breach will be dealt with in the criminal court. So they will be taken to the magistrate's court for that offence to be prosecuted effectively. So the enforcement side of a respect order will be something that is much more familiar to the police, and we won't have for those orders what we sometimes have now, which is we've arrested somebody. Yeah, we've gone to court. Oh, I'm at court. You're not here. We're at the magistrate's court. Okay. So they will be right to be at the magistrate's court. So it's a civil remedy, civil application in the county court, but breach is then criminal offence for which the police would be involved. And because it's criminal offence, that is then pursued in the criminal courts. So actually, for the county court, as soon as that order is made, that's it, they're done. That's the end of it for the county court.
Yeah, thank you. I just want to pick up on a couple of questions, just because obviously I know the value in some of this morning is about people being able to ask questions and get some answers. So I'm just going to pause. Question from Darren: would a solicitor need to apply for a respect order, or would police and local authority workers be able to request?
In terms of from a rights of audience point of view, so it's going to need to be a legally qualified person in applying for a respect order, you said, didn't you?
Yeah.
Sorry. In order to apply for a respect order, if you have permission to represent yourself, your organisation in the county court, you will be able to do that even if you are not a solicitor. One of the things that we already have across the courts is some judges, some courts do not like agencies representing themselves if they're not legally qualified. And even historically, some judges and courts that were happy with it, they very much have switched and they've gone, no, we're not happy with that. You will need to have authorization if you are not a legally qualified person from your organisation, and ultimately probably from the court, in order to be able to represent yourself if you're not legally qualified. One of the things that I don't know is, because breach of a respect order is going to be a criminal offence that then is prosecuted in the magistrates court, I don't know whether judges are going to take an even more kind of strict view about who is representing in order to be able to be given that order in the first place. We won't know until we start to do it. But I think that if you are used to self-representing, you do just need to be aware that it might be something where, just because you were allowed to do it previously, that isn't necessarily going to continue. And I think that because there is a lot more on the line in respect of the respect orders, you might find that there's a bit of a change in attitude. But in theory, yes, with the appropriate permissions, both from your organisation and from the court.
Yeah, no, thank you. That's really helpful. Yeah, and then talking obviously about there is costs attached to that, which of course there are. And I think the other problem as well is that we know the county courts are already heavily overstretched. And
yeah, and it's not getting better. It's not getting better at all. But let's just bear in mind that we're not talking about I don't think there's going to be more injunction applications because of this legislation, as in there are already tools to deal with ASB. So you're either using them or you're not. I don't think that this change in the tools is going to increase the amount of applications that are made. It shouldn't be, because you should just be dealing with the behaviour now whilst we've still got the tools that we've got. But I think there will be an element of pressure in terms of it's new legislation for the judges as well. You're going to need to be prepared to talk them through it. Don't just assume, oh, it's the judge. And this as well perhaps goes back a little bit to that self-representation point. Don't just assume that the judge knows what they're doing. Like, judges get given a lot less training than you would think. So you will absolutely need to be prepared to talk them through what a respect order is, what the test is, what they can and can't do. You might need to talk to them about enforcement and what that means. Just be prepared.
Julie raises a really interesting question, which may be one of those where we play our card and say we'll go away and find out. I am aware that there's some changes to the sentencing around, I think it's basically the principle being that it's more likely to be it's going to be a suspended custodial sentence if the sentence would be less than something like 12 months. And is that therefore going to have an impact on how attractive respect orders are?
Well, I suppose it depends on what you're trying to get out of it, doesn't it? In some ways, and this is true of the law that we use now, so the Anti-Social Behaviour Crime and Policing Act injunctions that we use now, for some perpetrators, a suspended sentence is actually worse than a custodial sentence, because that term of suspension is hanging over your head, usually for the remaining duration of the injunction order. So they know what might be coming if they do anything else. We definitely don't see that many defendants who breach the terms of the injunction when there is a suspended sentence hanging over their head. For those who do, then fine. It usually turns into a custodial sentence. But really, I suppose it's what are you wanting to achieve by the breach being pursued? Is it that you want that person to have a custodial sentence? But to a certain extent, this is out of your hands anyway. There is already sentencing guidelines for committal proceedings now in the county court. So giving somebody a custodial sentence, that's got to be for the behaviours that are at the very top end of breach, and isn't something that county court judges or magistrates are kind of wanting to give out across the board. They're reserved for the most serious offences.
Another question around breaches of respect orders around, will the police be required to apply the necessity test for arresting for breach of respect order? My understanding is yes.
It is in yes, but it will be, is there evidence to demonstrate that the term of the order has been broken? And if there is evidence to demonstrate that, and don't forget, it's going to be exactly the same as the county court committal process. We're on criminal standard of proof for breach. Then that means, is the person going to come forward? Are we going to have direct evidence of this breach? Are we going to be able to prove this breach to the relevant standard? So all of those usual rules will apply.
Someone's mentioning the fact about action on breaches not being sort of proactive, or people not being arrested for breach of injunction, breach of respect order, to be very similar to the situation that we have now with injunctions. And I suppose that is one of the potentially downfalls for a respect order, is you might be a housing provider or a local authority applying for the respect order, you might get the respect order, but then you kind of lose control management over the breach side of things because it becomes in the criminal realm. I mean, I think we could do a whole session on that. I think my response here would be, this is why there's that real importance of having those partnership conversations now,
Yeah.
to get some understanding. And it ties in actually to one of the other questions that came in, which is, I think it's really interesting that there was a legal consultation requirement for the ASBO. So the local authority had to consult with the police and vice versa.
Mhm.
There were very limited times where a housing provider could apply for an ASBO when it was in possession proceedings, and that consultation requirement applied there. But there isn't an equivalent for the respect order. And I think really there has to be something that you do locally, because to me it feels quite foolish to be applying for a respect order and not involving the police in that conversation before you even make the application, given the fact that they will be managing the breaches. So I think there has to be that consultation. It just needs to be something we do ourselves rather than being made to by the law.
100%. And one of the things that I will be saying to clients when we're talking about, do you go for a housing injunction or do you go for a respect order? It will be on a little bit of a case by case, region by region basis of how good is your relationship with the police. You know, if you don't have a very good relationship with your police, with your, you know, with the force that would be enforcing this order, then you've got to think to yourself, do we then want to relinquish control of the order to an agency that we don't have any relationship with whatsoever? It's part of that planning, isn't it? It's part of that getting ready for these things to happen. And I know it's easier said than done to say, create some good relationships with these agencies. I know it's not always for want of trying, but it will be a factor to take into account, of what do we think the chances of the order being enforced actually are.
Absolutely. There's some sort of technical questions around content. I mentioned the written warning that needs to be given for an activity requirement. And I think it's quite interesting. We're used to kind of the language positive requirement and prohibition from kind of the injunction and the CBO. And it was almost with the respect order, there's almost sort of three, because the positive requirement kind of gets split into a positive requirement and an activity requirement. And quite simply, what the activity requirement is it's more about getting someone to go to like an alcohol class. It's that more support provision, whereas the positive requirement is more of a, you know, you must get a skip to clear your garden type thing. So it's that it's the where it's an activity requirement, it's getting them to want to take an activity. So the written warning applies to a breach of an activity requirement. A question in terms of what should go into it. So if you have a look at the Crime and Policing Act, H1 talks about the duty to give a warning for breach of activity requirement, and talks about what must be in it. It just says at the moment it must be in writing. It must describe the circumstances of the failure, so i.e. what have they not done, and it must inform the respondent that if they were to breach it again within a period of the next 12 months, that then they would be dealt with through the court process. It has to be given by hand or sent by first class post. I suspect this will be one of those things that there is a bit more detail in the statutory guidance, but from a legal perspective, they are the things that would need to go into a written warning. And it's probably worth saying as well that there is a similar section about risk assessments, and what needs to go into a risk assessment. So again, have a look at the relevant section in the Crime and Policing Act. And actually what you will see is that the risk assessment is pretty much the proportionality assessment that most of you would be doing before you take any legal action anyway. So talking about things like what things have been tried before. So have a look.
Yeah, but just on that point, so sorry to interrupt, Janine, but just on that point, don't forget the proportionality assessment applies if you think that somebody has got a disability, because it's the Equality Act considerations that are coming into play. You might have at the moment a file where actually there is nothing about the file that demonstrates somebody might have a disability. You might have even had a conversation with the person beforehand and asked them, have you got any disabilities that we need to know about and what have you. There are still people who don't produce a proportionality assessment when they have determined that on the information they have available, there is no disability. So Yes, absolutely. If you are completing a proportionality assessment, and maybe you do just do it as a matter of course anyway, and you know what you put there is we don't think this person has got a disability, but in any event, we're considering these things. Very definitely, you could then look to combine the risk assessment that is required by all three remedies now, so that it's not just the respect order that requires it. So you will need it for the housing injunction, which is new, and you will need it for the youth injunction. So you will be able to combine it. But if you are an organisation or person who does not complete a proportionality assessment when you are satisfied that there is no disability, obviously you'll still have referenced that you've considered that in your witness statement. You can't forget to do the risk assessment. And one of the things that I think is also really interesting about the risk assessment is you've still got to do that risk assessment even on a without notice. So we all know, don't we, that we could be in a position where this morning an incident happens. It's really, really serious, and we want to get it in court this afternoon. And actually, the focus is let's get the witness statement done, let's get the evidence ready. Boom, come on, we'll make an appointment at court. Let's go. You're going to need to make sure that you have factored in this part of the process for your without notice. And it's not difficult. You know, it's just going to be a habit thing, isn't it? It's just going to be making sure that your procedure makes it clear that this risk assessment needs to be done and addressed in the evidence. So you will have to confirm in your evidence that you have carried out this risk assessment and what the answers to those questions are.
Yeah, and again, just to give people a little bit of an indicator, if you look at J1 of the legislation, it talks about what must be in a risk assessment. This is for the purpose of the respect order, and it talks about the risk of people being caused harassment, alarm, or distress. So essentially, what is the impact of behaviour, any vulnerabilities of the respondent, any alternative means of preventing the respondent from engaging in ASB, so i.e. what have you done before you've looked at a respect order, and any other matters as the person considers relevant. So yes, that is a legal so please make sure you do it, otherwise you could get your application struck out on the basis of not complying with what is essentially a technicality. But I think your proportionality assessments, if you use them outside of the Equalities Act, like Lindsay's just mentioned, should hopefully contain a lot of that. What I would be doing now is getting what your proportionality assessment is at the moment and kind of cross-referring it against the legislation to see if it has everything in there that you need to be able to meet that part of the legislation.
And all good witness statements should already be including that information, just to be clear. You know, so if you already draft amazing witness statements, that's in part probably because you're already doing what is covered by that risk assessment.
I am really conscious of time, so I'm going to move us along. I know there are some more questions in the chat box, but we're going to have to commit to answering them after the session by sending around some responses, because we're not going to get through everything. And I did want to pick up on the closure order stuff, because obviously that's something that we've had a number of questions about. So there are a couple of questions just to tie up these sections, which we'll just rattle through quick fire. Question which was, can we use a breach of the respect order as a ground for absolute possession?
If it's a proven breach, as we have with the injunctions now, then yes, you can.
Yep. And also where we talk now about housing injunctions and youth injunctions, they are also included, aren't they?
Yeah.
We had a question about who can use the housing injunction, because I think we've obviously got some people who have worked in ASB as long as we have and remember the Section 153 Housing Act injunction, which we used to call a housing injunction then, and that was only for social housing providers. So I think there's been some concern that we're going back to those days where it's, you know, the housing injunction can only be used by housing providers. Set us straight, Lindsay.
Yeah, so it's not just for housing providers. It's just that it's being called a housing injunction because the test is where the behaviour relates to housing related, housing management function type behaviour. That's where the housing injunction reference is coming from.
And so there was a question in the chat box, which is probably apt to address now, which was around, you know, respect orders going to be for sort of over 18s and youth injunctions for under 18s to a certain extent. But actually what we're probably the fullest way of answering that is if the behaviour is linked to residential property and somebody is being impacted in their home, then and they are over 18, then that's where you're probably looking at the housing injunction, because it's the nuisance or annoyance test. If it is a situation where the person is over 18 but the behaviour is non-residential, town centre, etc., it's going to be a respect order. Anyone under the age of 18 is going to fall within the youth injunction.
Yeah, which is exactly, well, obviously we don't have the two respect order and housing injunctions now, but we already have youth injunctions, and people aren't really using them as much as they should, in my opinion. But there's not really a huge change on that youth injunction front. So you will carry on as normal, really, in respect of that.
Great, thank you. Now, there has been a number of pieces of helpful guidance that various kind of Home Office departments have been kind of publishing over recent weeks, and they are helpful, but there have just been a couple of sentences where perhaps the phraseology hasn't been particularly helpful and it's been a bit confusing. And one of those things was there was a reference into some guidance which talked about registered providers being able to use the closure notice, which then got people a bit concerned about whether, you know, if a housing provider is only able to use the closure notice, and if so, who then picks up and goes for the closure order. Again, just to clarify that point for people.
Yeah, absolutely. So RPs will be able to apply for closure orders. There would be literally no point in them being able to issue a closure notice if they weren't then the responsible agency for following through and doing the closure order. It's just really unhelpful that the guidance kind of referenced the notice and didn't then go on to say, and then you can apply for your order. But no, that power in its entirety will be a remedy that is available to RPs.
And there is another piece of guidance as well that suggests that the CBO has changed and is now for over 18s only. And again, that is not the case at all. The law doesn't make that change. I think the important thing here is, yes, we hope that the guidance is accurate, but obviously the important thing is the legislation, and it's looking back at actually what does the legislation say. So, but we are, where we spot these sort of inconsistencies or things that aren't particularly helpful, we do flag them up with the relevant department. So please don't think we sit there with our red pen and then don't do anything about it. We do feed it back, and in the main they are fairly accurate. I will give them the dues. So let's just very quickly then talk about what's going on with the durations around closure notices and closure orders, because as I mentioned in the intro, you know, we had this kind of last minute tabled amendment to extend closure notices and to extend closure orders for up to 12 months. 6 at the moment is the maximum, 2 possible periods of 3 months. It seemed very much that this is coming from the ability to be able to use them for commercial premises, so shops that are involved in organised crime, that are selling counterfeit goods, you know, that are fronts for various different things. The ability for Trade and Standards Police to be able to use closure orders is actually really powerful in those circumstances, but that 6 months isn't quite long enough. The consultation did open, I think, last week. I can't remember the date off the top of my head. It closes on the 31st of this month. And what I found really interesting was actually the questions don't seem to tie down the scope of the consultation to commercial properties. So if you are kind of a housing provider or a local authority or police and you deal with issues in residential properties and you think there would be some value in closure orders being possible for up to 12 months, then it is still worth responding to that consultation if you have any examples of how and why it might be useful. I don't know if there's anything you want to add to that.
Yeah, I'd just like to give you an example, which you probably already know, of how and why it might be useful, which is even though it is an absolute ground for possession, meaning that the court doesn't have discretion to do anything other than make your order, proportionality for Equality Act cases still comes in on mandatory possession. There still is an actual defence available under the Equality Act in respect of that. But even though in theory, they're straightforward, brilliant, we're going to get our order at the first hearing, some courts are finding it really difficult to give us a hearing date very quickly for a first hearing. And some courts are finding it very difficult to give us a bailiff appointment that is, you know, even remotely quick. So my view is it would be helpful if what's happening is in conjunction with the closure order, you are issuing possession proceedings to recover back possession of the property. It is meaning that you're not ending up in the situation which we see quite frequently now. A closure order is going to expire. It's already been extended. So you've had the 6 months and you still haven't had your possession proceedings dealt with. You can apply for a brand new closure order after the 6 months. There's nothing to stop you doing that as the law stands at the moment. But wouldn't it be great if we could have that longer period? And one of the things to bear in mind as well is you can make an application for a closure order to be discharged. So let's say that there is an order that's made for 12 months, and if after 8 months you've recovered back possession of the property, an application could be made for that closure order to be discharged so that you can go through your voids process, you can get it relet, it's back in your stock and you've got the money coming in. So don't let the duration be something that puts you off if you're thinking about, well, we're going to be losing money for that period of time, because that doesn't necessarily have to be the case.
Yeah, we have rightly so got a bit of a virtual hand slap because we've slipped into using acronyms, and I'm so sorry. So RP, we mean registered providers.
So sorry, that's
what used to be
apologies.
registered social landlords, housing associations, essentially. Yes, sorry, that's what we mean by RPs. Forgive us. So yes, so I think there's going to have to be some common sense approach to this, isn't there? Like, I think for me, it's always good that if there is that ability to have a longer order where it's needed, but I would suspect that if we're talking about potentially making somebody not be able to use their property for up to 12 months, then you're going to have to show that it is because you've made an application to deal with the problem that hasn't been dealt with yet, or you're doing something else. It's not going to be good enough, I would argue, to say we need a longer order because we just haven't served notice in time, or it's not there to be a sticky plaster over bad case management. It's there where it's genuinely needed. And it might be the case that you've got a partial closure order in place to protect a vulnerable person. So actually it's in everybody's interest, including the tenant, for that order to be longer. So I can see there being opportunities for it being very useful even in the residential.
Yeah, just would absolutely encourage people to be responding to the consultation. That's what it's there for. So please do.
Absolutely. But just again, so that we're really clear on where we are at the moment, the legislation is as is with the closure order. So on the face of the legislation at the moment, it still talks about the periods that we are used to from the ASB Crime Policing Act. But as I said, we know that the Secretary of State, after consultation, has got the power to recommend a longer period. So watch the space, respond to the such guidance. We did have a question about demotions.
Demotions, please, people, tell me that you're not using demotions. Can you tell I've never been a fan? So demotions are not affected at all by this legislation. They will be affected for registered providers by the Renters' Rights Act. So just for those of you who don't know, a demoted tenancy was taking a secure or for local authorities or assured for registered providers tenancy and demoting it to a lesser tenancy. So for local authorities, it was actually demoting it to a demoted tenancy. That's covered in its own right in the legislation. And for a registered provider, it was demoting it to an assured short hold tenancy. I'm sure that all of you are aware of the Renters' Rights Act and the changes that is introducing in respect of doing away with assured short hold tenancies. So that will obviously have an impact on demoted tenancies for registered providers, because assured short hold tenancies will not exist. For local authorities, it wouldn't have an impact because that tenancy wasn't demoted to an assured short hold tenancy. It was demoted to a demoted tenancy for which you serve a specific notice. And so in theory, they would continue under that regime.
Thank you. Well, that really neatly brings us to 28 minutes past 10. So somehow magically we've managed to keep within time. I hope that's been helpful. I know it's been quite bitty, but obviously as I said, we just wanted to make sure that we got your questions answered. I think for me, the key things to take away is we can't use the tools now, but watch the space for the commencement orders. And obviously, if you're not part of our mailing list, then why not? Because you'll definitely find out first when those commencement orders come out. Think about what things that you can start doing to prepare now, those partnership conversations, looking at some of those templates that you can start to create. Um, Fill in your consultation regarding the closure powers. Let's see if we can have some influence around that. Anything you'd like to add, Lindsay?
The only thing I would add, because I saw it as a question buried deep within, is somebody said, can't you apply for a respect order and be given a housing injunction? Yes, that could happen, and vice versa. So I take that as, do you know what? See it as a win-win. It might be that you think, oh, I really want to apply for a respect order, but we've never done it before. We don't know what's going to happen. Okay, fine. Give it a go if that's the order that you think is appropriate, and then work on the basis of, well, you could be given a housing injunction if you don't, if the judge doesn't want to give you a respect order. Vice versa, you could apply for a housing injunction and the court could give you a respect order. If I was applying for a housing injunction, I would be very much trying to persuade a judge not to give me a respect order, because there must be a reason that I had considered the housing injunction was the appropriate one in the first place.
Amazing. Thank you everybody for joining us. As I said, we will go through, pick out the questions that we either missed or didn't have time to answer. Please bear with me. As you can imagine, it's a really busy week this week, but we will aim to get something out to you by the end of next week. Also, recording will be available in the channel and also on our website. But yes, thank you, and go off and continue with all your amazing activity during ASB Awareness Week. Thank you very much. Bye bye.
Have a great day, folks. Bye.